The subdivision would have worked. It worked for Dale Briggs over in Millhaven Township 10 months earlier, with the same mechanism and the same kind of debt in the same county recorder's office processing the same type of documents. The difference was 12 days. James Colfer stood at the fence line of his 320-acre operation in Hardin County, Iowa, on a Thursday morning in November 1985, and watched the auctioneer work through everything he owned. Not the expansion parcel, not the debt-heavy ground he had been trying to cut loose. All of it, both parcels, the home quarter and the machine shed and the grain bins and the 160 acres he had farmed since he was 19 years old. He had done everything correctly. He had understood the mechanism. He had hired a lawyer, paid for a surveyor, filed the documents on time. The window had not closed. The money had not run out. The paperwork was in order. The county recorder's office had a 12-day processing backlog. That was the whole of it. James Colfer was 42 years old in the fall of 1985 and had been farming in Hardin County his entire adult life. He was not a man who had overextended recklessly or borrowed without thinking about the numbers. He had bought the northern 160 acres in 1978 because the agricultural economists were saying land values would keep climbing, and every lender in central Iowa was willing to finance expansion at rates that seemed manageable when corn was above $3. He had made the same calculation that half the farmers in his county had made that year, based on the same information with the same result. By 1983, the result was a $162,000 variable rate mortgage on ground that had dropped 40% in value and an operating note that was consuming more than the farm could produce. The southern 160, the original family ground, the acres his father had bought in 1951 and paid off by 1965 and left to James when he died in 1977. That ground had no debt on it. His father had been careful about debt in a way that James had not always been, and the result was 160 acres that were clean and free and generating enough income to have kept a smaller operation solvent. Under the combined deed, the bank's claim on the northern mortgage cast a shadow over both parcels. If the bank moved on the northern debt, the legal exposure covered everything. He had understood this for 2 years before he did anything about it. For 2 years, he had hoped that corn prices would recover enough to service the northern mortgage without requiring a structural decision. They had not recovered enough. By September 1985, the cash flow math had been negative long enough that the property tax had gone unpaid for 18 months and the county was moving towards certification, and James had finally admitted that hoping was not a strategy and that the window Edward Polk would later describe as adequate was not going to stay open indefinitely. To understand why 12 days was the difference between keeping the farm and losing it, you have to understand how the deed subdivision mechanism worked, because it is important to know that this was a real legal tool, properly used by a number of Iowa farmers in 1984 and 1985, and that it worked the way it was supposed to work in most of the cases where it was tried. The mechanism was straightforward. When a farmer had two parcels of land under one deed, a common situation for operations that had expanded by adding adjacent ground, a single foreclosure action or a single tax lien could attach to the entire deed and take everything at once. One deed, one legal target, one action to end the whole operation. But a deed was a document, and documents could be restructured. If a farmer subdivided his single deed into two separate legal descriptions before a lien was certified against the full parcel, each new deed became an independent legal entity. A lien or a foreclosure proceeding that attached to one deed could take that parcel and leave the other untouched. The farmer lost half. He didn't lose everything. The critical word was before. The subdivision had to be filed and recorded, meaning processed by the county recorder's office and entered into the official land records, before the lien was certified against the original parcel. Once the lien was certified, it attached to the legal description that existed at that moment. If the subdivision had been recorded by then, the lien attached to the new description, covering only the parcel it was properly assigned to. If the subdivision had not yet been recorded, if it had been filed but was sitting in a processing queue, the lien attached to the original description, which still legally existed until the recording was complete. Filing was not recording. Filing was submitting the documents to the county recorder's office. Recording was the act of entering those documents into the official land record. The two were not simultaneous. Between filing and recording, there was always some amount of time. Usually it was short. In Hardin County, Iowa, in the fall of 1985, it was 12 days. Here's what James Colfer knew when he walked into the office of a Marshalltown attorney named Edward Polk in the third week of September 1985. He knew about the mechanism because word of it had traveled through the farm community in the way that useful information travels when people are desperate and paying attention. He had heard specifically that a farmer in Millhaven Township had used it successfully, had split his 320 acres into two parcels and surrendered the debt-heavy one and kept the original family ground. He didn't know the man's name. He knew the story had worked. He had a similar situation. His 320 acres in Hardin County were held under one deed. The northern 160, the ground he had bought in 1978 at the height of the boom, carried $162,000 in mortgage debt at a floating rate that had climbed above 17% and had only recently begun to ease. That parcel was the one the bank had a claim on. The southern 160, the original family ground, the home site, the machine shed, the grain bins, the acres his father had paid off and left to him, had no mortgage. It was clean. Under the combined deed, both parcels were exposed to any action the bank took on the northern debt. The county's property tax account was also delinquent, $6,800 owed across both parcels, because James had stopped paying taxes in 1984 when the cash flow stopped working. Both the bank and the county had been building their cases, and the county's tax sale was the more immediate threat. It had a scheduled date, it was moving towards certification, and the window for James to act was closing. Edward Polk was a careful attorney who had handled agricultural land work in the region for 20 years, and who understood the mechanism James was describing. He confirmed that the subdivision was legally available, that it could be done while the tax delinquency was outstanding as long as the county lien had not yet been certified against the full parcel, and that the process required a licensed surveyor to draw the new legal descriptions and a properly drafted subdivision document filed with the county recorder. He quoted James $950 for the work, which was slightly more than the $800 the farmer in Mill Haven had paid, because of the additional complexity in Hardin County's legal description format. James wrote the check. Polk also walked James through the legal pad arithmetic that determined whether the mechanism was viable. He did this at the meeting on paper, the way a careful attorney does when he wants his client to understand the structure of what they are attempting, rather than just trust the outcome. The northern parcel carried $162,000 in mortgage debt at a current rate of 14.5%, which had come down from its 1981 peak, but was still running at an annual interest cost of $23,490. The farm's net operating income in a normal year was approximately $19,000 after inputs and land costs. The annual shortfall was $4,490 before any principal payment, which explained why the operating reserves had been exhausted and the taxes had gone unpaid. The math had not worked for 3 consecutive years and was not going to start working at current prices. The southern parcel, by contrast, had no debt. Its assessed value for tax purposes was $118,000. Its actual market value in fall 1985, after the land price collapse, was approximately $142,000. If the subdivision was completed and recorded before the lien was certified, the southern parcel would be legally separate from the bank's claim and from the county's tax action. James would lose the northern 160. He would keep the southern 160, the home site, the machine shed, the bins, and the 160 acres that his father had paid off. Polk was clear about one condition. The subdivision had to be both filed and recorded before the county certified the lien. Filed meant submitted. Recorded meant processed and entered into the official land record. He said specifically, do not assume that filing is the same as recording. They happen at different times. We need the recording to be complete before the county acts. James had understood this. He had written it on the notepad he kept during the meeting. Filing not equal to recording. Window equals before recording, not before filing. He had understood it and had believed, as Polk had believed, that 4 weeks was sufficient time. Here's what Polk told James about timing, which is the part that matters most and the part that James held on to in the months afterward. The county's tax certification was scheduled for the third week of October. The subdivision needed to be filed and recorded before that date. They had approximately 4 weeks. Polk said that was adequate time. He said it with the confidence of a man who had done this work before and understood the typical processing timeline at the county recorder's office. The surveyor completed the legal descriptions in 10 days. Polk drafted the subdivision documents in 4 more. On a Friday afternoon in the second week of October, the documents were filed at the Hardin County Recorder's office. The filing clerk accepted them, stamped them with the date and time of filing, and placed them in the processing queue. The Hardin County Recorder's office was, in October 1985, working through a significant backlog. The farm crisis had generated an unusual volume of property transactions, lien filings, deed modifications, and estate documents, all of which required processing by the same office with the same staff that handled a normal year's volume. The recorder's office was not negligent. It was not slow by choice. It was working through a queue that had grown considerably larger than the office's normal processing capacity, and the documents filed on a given day were typically being recorded 10 to 12 days after their filing date. On the 8th day after James Colfer's subdivision documents were filed, 4 days before they would have been entered into the official land record, the Hardin County Treasurer's Office certified the full tax lien against James Colfer's property. The lien attached to the legal description that existed in the official land record at the moment of certification. On that day, the official land record showed one parcel, 320 acres, under a single deed. The subdivision documents were in the processing queue. They had been filed. They had not been recorded. As far as the official land record was concerned, they did not yet exist. The lien covered everything. Edward Polk learned about the certification date 4 days later, when James called him after receiving a notice from the county. Polk reviewed the timeline carefully, consulted the recording logs, and confirmed what the dates showed. The filing had been timely. The recording had been processed 12 days after filing, which was within the office's stated backlog. The certification had occurred on day 8. He called James and explained the situation. He was direct and precise about it. The window had closed, not because the documents were filed late, but because the recording did not happen before the certification. Under Iowa law at the time, the protection that the subdivision would have provided depended on the recording date, not the filing date. The filing date was a record of submission. The recording date was when the legal reality changed. "Is there anything to fight?" James asked. Polk was quiet for a moment. He said there were arguments that could be made about the county's processing backlog and its effect on a farmer who had filed in good faith within the appropriate window. He said those arguments were not strong. The law was clear about recording dates. The backlog was not the county's fault and was not considered a legal exception to the recording requirement. He said he would file whatever James asked him to file, and that he should understand the likely outcome before deciding whether to spend money on it. James did not file anything further. He did not have the money, and Polk had been honest with him, and there was field work to finish. He spent the following 2 weeks combining his corn. The yield was 94 bushels per acre on the ground he was still farming, which was below his average but functional. He had rented the neighboring farmer's combine because his own equipment was listed as collateral on the bank's claim, and he had decided after a conversation with Polk that the more orderly he kept the harvest, the better his position in any subsequent negotiation about the deficiency. He combined the crop as though the auction was not coming. He hauled it to the elevator, got the checks, and took them to the bank in Eldora the same day, where the loan officer accepted them against the outstanding balance without comment. The combines and the planter and the tractor were inventoried by the bank in October in advance of the auction. A man from the bank's asset management team drove out on a Tuesday afternoon and walked through the machine shed with a clipboard. James watched him from the door of the shop and answered the questions he was asked and did not volunteer anything. The man thanked him when he was done and drove back to Eldora. James, Spent the rest of that afternoon in the shop doing maintenance on the tractor because the maintenance needed to be done, and because he was not ready to stop working on the machinery he had kept running for 20 years. The auction was scheduled for a Thursday in November. James called his brother in Iowa City the week before to tell him it was happening, and his brother drove out on the Wednesday evening. They sat in the kitchen of the farmhouse, a house that was also going in the auction, that James had lived in for 16 years, that his father had built in 1954, and they did not say very much. His brother asked whether there was anything to be done, and James said there was not. His brother said he was sorry. James said he appreciated it and that he was going to bed because the auction started at 9 and he intended to be there. The foreclosure on the full 320 acres proceeded over the following months. The bank held the mortgage on the northern parcel and had coordinated with the county on the tax sale. James hired a neighboring farmer's combine to finish his corn harvest that fall. The crop was in the ground, and he intended to see it through regardless of what was happening with the land. The harvest check went to the bank. It covered a portion of what was owed on the operating note. It did not affect the underlying land proceeding. The auction was in November. Both parcels combined sold for $187,000 against a total debt position of $224,000. James walked out of it owing approximately $37,000 on the deficiency, which the bank agreed not to pursue immediately given his financial position. The debt sat on his record, accruing at a reduced rate, for the better part of a decade before it was resolved through a settlement. Here's what the timeline looked like, written out the way James wrote it on a piece of paper sometime in the winter of 1986, in the apartment in Eldor he had moved to after the farm sold. He was not a man who kept records without purpose, and this was not a record he kept for any practical reason. He kept it because he needed to understand exactly where the window had been and where the certification had landed relative to it. Filing date, October 11th, 1985. Certification date, October 19th, 1985. Recording date, October 23rd, 1985. The window between filing and certification was 8 days. The recording took 12. The subdivision would have provided full protection if the recording had happened before day 8. It happened on day 12. 4 days. 4 days was the distance between the outcome James Colfer got and the outcome Dale Briggs got in Millhaven 10 months earlier, with the same mechanism, the same type of attorney, the same legal process. Here's what James could have done differently, and it is worth saying this plainly because the lesson is practical and specific, and not just a general warning about reading contracts carefully. Before filing the subdivision documents, he could have called the Hardin County Recorder's office and asked a direct question. What is your current processing time between filing and recording for land subdivision documents? That question takes 5 minutes. The answer would have been 10 to 12 days. With that answer in hand, Polk could have compared the processing time against the county's certification schedule, identified the gap, and made a decision about whether to request an expedited recording. Some county offices offered this for a fee, some did not, or whether to accelerate the filing to earlier in the process, or whether to contact the county treasurer's office and request a brief delay in the certification date to allow the recording to complete. None of those alternatives was certain to work. An expedited recording request could be denied. A delay in certification was a negotiation, not a right. But all of them were possible conversations that a 5-minute phone call to the recorder's office would have made available. The information was public. The question was ordinary. The answer was the piece of information that would have changed the entire structure of the situation. James Colfer did not make that call because he did not know to make it, and he did not know to make it because the distinction between filing date and recording date was a detail that neither he nor Polk had treated as the critical variable. Polk understood the legal mechanism. He had used it before in cases where the timing worked. He had not checked the processing timeline in Hardin County in October 1985, because checking the processing timeline had not been necessary in the previous cases. It had not been necessary because the recording had been timely. The backlog that existed in Hardin County in the fall of 1985 was a consequence of the farm crisis itself, the surge of property transactions and lien filings that the crisis had generated, And it was not a condition that had existed in the county the previous year or in the counties where the mechanism had been used successfully. The backlog was a fact. It was a public record. The recorder's office was not hiding it. Nobody had asked. Here's the thing about mechanisms that work. They work within a system that has its own timing, its own backlogs, its own procedural realities that are not visible from the outside until you're already inside them. The subdivision mechanism was legally sound. It had been designed and used precisely for situations like James Colfer's. It had worked for Dale Briggs because in his county, in his time frame, the documents were processed before the lien was certified. It did not work for James Colfer because in his county, in his time frame, they weren't. The mechanism itself did not fail. The timing did. The deficiency the bank agreed not to pursue immediately was $37,000. It stayed on his credit record for 9 years, accruing at a negotiated rate, until James settled it in 1994 for $18,000, which he had saved over the preceding 8 years working at the elevator and living in the same apartment he had moved into in December 1985. The settlement was processed on a Thursday in April. He did not mark the occasion in any particular way. He went to work the following Monday as he always did. James Colfer found work managing a grain elevator in Eldora. He was good at it. He knew grain, and he knew the financial pressure that farmers brought to the scale every fall. And he was patient with the ones who were not paying attention to their numbers, the way he had not paid attention to the county recorder's processing timeline before it was too late to ask. He worked there for 14 years. He did not buy land again. Knowing the mechanism doesn't mean the mechanism will protect you. The law says what happens when everything works as designed. It does not guarantee that everything will work as designed. Between the filing and the recording, there is always some amount of time, and in that time, the world does not stop moving. The question worth asking before you depend on any procedural protection is not just whether the mechanism is sound, but whether the system that administers it has the capacity to process it before the window closes. In the fall of 1985 in Hardin County, Iowa, it did not. What would you do differently? If you had known that the recorder's office was running a 12-day backlog and the certification was scheduled for day 8, what would you have changed? That's not a rhetorical question. There are answers. They require knowing things that James Colfer did not know and had no obvious way to find out before he needed to.